Good morning, everyone. Thank you for joining. There's people still joining the webinar, so I'm just going to wait a couple of minutes uh, so everyone can be let in, and then we'll start. Okay, well, good morning to those who've just joined, and I think we'll now make a start. Welcome to this landmark webinar on electricity networks. It's the first in a series of webinars that I'll introduce a bit more formally in a moment. First of all, can I just pick up some housekeeping points? Your microphones are muted, so you don't need to adjust anything to ensure that you're not being heard. If you want to ask questions, please can you do that in the Q&A section that you should see at the bottom of your screen? It might be at the top of your screen, depending on your settings. And if you don't want your name to be included with the question, you need to elect to send it anonymously. We will pick up questions at the end of the session. I can't promise that we'll deal with all of them, but we'll try and have a stab at as many as possible. The webinar is being recorded. Afterwards, you'll receive a link to the presentation and to the recording, so you can have access to all the slides and the recording at that point. If you get disconnected, feel free just to click on the same link that brought you here and you'll be able to be let back in. So those are the housekeeping matters. Let me then just briefly introduce the series that we are proposing to do. As you will know, Landmark spreads its expertise across planning, public and property law, as well as dealing with matters relating to environmental law, compulsory purchase and the valuation aspects of that in related areas. The challenge that the country faces of delivering clean power by 2030 and meeting a shift in the way in which electricity is generated and used across the country is one that touches on all of the areas in which we specialise. And the idea of this series is to pick up some themes that emerge across our practice areas and start to draw them together in a series of webinars over the coming months. This is the first one. We're going to look at electricity networks, and we are going to address both the development consent order side of things, planning reforms, and compulsory purchase and way leaves for today. So very briefly, I will introduce our speakers. I'm Richard Turney KC here at Landmark, and I practice in planning and environmental law principally, and do a lot of work relating to energy development. Our first speaker will be Nick Grant. He's a planning, environment and compulsory purchase specialist. He's ranked in all the major directories and in the Planning magazine as one of the top juniors, and he's on the Attorney General's B panel of counsel. His recent court work includes Finch in the Supreme Court, Fry, which is currently before the Supreme Court being considered on habitats regulations, and also acting on a recent challenge to the Thames Water Resources Management Plans. And he assisted with Lord Banner KC's review of judicial reviews of nationally significant infrastructure projects. His DCO work includes promoting Sonaca Solar Farm, where he worked with me, and representing Natural England on the Lower Thames Crossing DCO, and various other authorities on the M6 Junction 9 and Luton Airport DCOs. After that, we'll hear from Odette Chalabi, who is a specialist in planning, infrastructure, environmental and public law. She has a particular experience in energy planning, in particular in relating to solar and battery storage inquiries and hearings, which include schemes in the Grey Belt, schemes affecting heritage assets, and issues relating to the use of best and most versatile agricultural land. She is the co-author of 2 chapters in a new legal textbook on energy law, which is to be published later this year. And she's currently working on challenges relating to airport expansion and a nuclear power station project. And then after me, the last speaker will be Kim Zia, who's a specialist in both property and planning work. And she focuses in particular on the areas where those 2 subject matters overlap, relating to matters such as option agreements, restrictive covenants, nuisance, and public open space trust issues. And Kim routinely advises on planning issues that arise within property disputes, as well as property matters which emerge in planning matters, and has been involved in several high profile proceedings across those areas of law, including 2 cases before the Supreme Court. And she acts for a broad range of clients, given that mix, from private individuals to large corporations, local authorities and other public bodies, and local residents and community groups. So those are your speakers. Without further ado, I will hand over to Nick, who is going to address the webinar on matters relating to national policy and the NSIP regime.
Thanks, Richard. Good morning, everyone. As Richard said, I'm picking up on national policy, particularly EN5 and the NSIP regime. I'll start with the NSIP regime, then national policy, and I'll come on at the end to talk a little bit about the reforms that are on the table. So I'm sure many of you will be familiar with the DCO and NSIP regime, but it helps understand the national policy discussion that comes afterwards. So for certain nationally significant infrastructure projects, all of which are defined in the Planning Act 2008, you need a development consent order, or a DCO, in order to permit them. And a DCO, again, as many of you will know, doesn't just permit, it's not just a planning permission, but it can also roll up other powers, for example, of compulsory purchase. Given we're dealing with electricity networks today, the relevant section is section 16, the NSIP is electric lines above ground with nominal voltage of more than 132 kilovolts, or 132 kilovolts and above, length of 2 kilometers, and which isn't a replacement line. On top of those statutory listed DCOs, the Secretary of State also has a power to bring other projects within the NSIP regime if he issues a direction under section 35. So you see that sometimes with certain other big infrastructure projects which aren't technically NSIPs, but the Secretary of State thinks they should really be treated as such. I think from memory, Thames Tideway Tunnel might have come within that. And consent, DCO consent, can be granted for both the NSIP development and, of course, section 35 development and what's called associated development. There's a lot of guidance around that. But for example, if you're consenting a solar farm, you might want a battery energy storage solution in there for grid balancing reasons, and that might well be considered associated development. Could I have the next slide, please? There we go. The reason that's important is because, and the reason I'm going to come on and talk about National Policy Statement EN5 is because there's a specific statutory regime where an NPS has effect, as it would be for the kinds of things covered by EN5. And effectively, that requires the Secretary of State to decide an application in accordance with that national policy statement. There are certain statutory exceptions, for example, if it would lead to the UK being in breach of its international obligations, or lead to the Secretary of State being in breach of a statutory duty, or the one that's most commonly argued at DCO hearings is the adverse impacts would outweigh the benefits. But effectively, the point and the entire thrust of the DCO regime and why it was instituted years ago in 2008 is that a lot of the debate is meant to happen at the national policy statement stage. Once that's promulgated, you can't really reopen matters that are settled in a national policy at DCO stage. So even though you might see objectors come along and saying, oh, well, the adverse impacts would outweigh the benefits, and therefore we should put aside the national policy statement, there's pretty trenchant High Court judgment from Mr. Justice Holgate that says what you can't do is use these exceptions to try and open up things that are already settled in the NPS. So that's why the NPS is important. And against that background, I will come on to EN5. So because we're talking about electricity networks today, EN5 is the main one of the key documents to look at. That's electricity national policy statement, electricity, energy, EN is energy, sorry, 5. Now that covers above ground electricity lines with nominal voltage of 132 or greater, more than 2 kilometers, not a replacement line, not otherwise exempt, effectively the same thresholds that you've seen in the DCO that I just went through, and any other kind of infrastructure and networks where they're either associated development or brought in within a Section 35 direction. So underground cables, for example, if a bit of a line requires undergrounding, associated infrastructure like substations, or occasionally lower voltage overhead lines. What's key, though, is there are a suite of national policy statements, hence in EN5 rather than just EN. And it's important that NPS EN5 is read along side EN1 and EN3. So number 5 is very clear in paragraphs 2.1.6 and the various other ones that I've put on your screen. The EN1, for example, outlines general assessment principles, and that applies to EN5 type development. It also contains policies on the assessment of impact. Again, that is explicitly intended to apply. EN3 contains information relevant to offshore wind, obviously potentially relevant to particularly the electricity networks coming from offshore wind farms in. And EN1 introduces the critical national priority badging for certain infrastructure projects. And effectively what that means is if you've got residual adverse effects that aren't habitats, regulations, impacts, for example, and those persist after the mitigation hierarchy has been applied, then the advantage of something being weighed as being demarcated as critical national infrastructure, as the Secretary of State and the national policy statements explicitly say, the adverse effects are unlikely to outweigh the urgent need for this type of infrastructure. So it's unlikely that development will be refused on the basis of residual impacts, save in very limited exceptional cases. And those are, as I said, for example, Habs-Regs impact, or an unacceptable interference with human health and public safety or defence, or an unacceptable risk to achieving net zero or offshore navigation. But basically, it's a big weighty policy support in favour of this. It says, yes, we acknowledge there are going to be adverse effects, but those are unlikely to outweigh the urgent need for this infrastructure. And EN5 explicitly applies that critical national priority badging to the overhead lines and to the lines that sort of come within EN5. And indeed, the general thrust, which is we absolutely need a stronger reinforced electricity grid if we're going to move to net zero, because we need to bring in renewable power. It's going to be a lot more power traveling through the electricity lines. That runs throughout EN5. It's a really important point of the policy. So what does EN5 contain other than that general point which I've just made? What it does include on top of EN1 are additional policies on factors influencing site selection and design, biodiversity, landscape and visual impacts, noise and vibration, electric and magnetic fields, and sulfur hexafluoride. And that's what I'm going to touch on today. So starting with site selection and design, the policy recognises that the siting of networks and lines is often determined by the start and end points and the system capacity and resilience requirements. Actually, it's not often a point over which a developer, often grid or ESO, has that much control, because you need to come from the wind farm and you need to push it into a substation and meet the grid. Nevertheless, they should still consider in the design of these networks, and indeed any other promoter looking at, for example, offshore networks, should still consider good design and whatever can be done to mitigate the impacts. There are limits to this. The policy is very clear that the Secretary of State has to bear in mind that the functional constraints of safety and security are paramount. And again, that may limit aesthetic appearance. There are 2 points that come out of the policy there. The first is holistic planning, and that is the government envisages that wherever possible, applications for generating stations and infrastructure should be made in a single application. I'll come back to that in a moment, because obviously there's a bit of tension between that and the idea of strategic infrastructure. But that's the second point, which is strategic network planning. There have been a couple of large exercises undertaken by the National Electricity Systems Operator since sort of 2023, one of which is the Holistic Design Network. That was a large review undertaken as part of what was called the Offshore Transmission Network Review. I'm trying to avoid all the acronyms. But effectively, that looked at coordinating system transmission proposals, the idea being to take a holistic look at what do we need and where, therefore, is the best place to put it. That's been taken forward now by the ESO's Centralised Strategic Network Plans, or CSNPs. And again, that aims to take a strategic view of the overall infrastructure required and therefore reduce the impacts. The idea being that single bits of strategic infrastructure might be less harmful than lots of dotted about bits of infrastructure as everyone brings a new solar farm or wind farm online and then just tries to plug it straight in. The EN5 contains specific provisions on offshore and onshore transmission. And again, it notes that coordination in strategic windows should be undertaken, or has been undertaken, through the HND and the CSNP process. There is an expectation that we will see more coordinated approach to offshore transmission. So, for example, it's anticipated that transmission assets may be consented separately to their rates. The wind farms will be consented separately to the cables to bring the power offshore, because, for example, those cables might end up serving multiple wind farms. And indeed, we've got an example of that going through the system at the moment. You've got the Morgan and Morecambe offshore wind farm projects, 2 separate wind farm projects, one of which has just received development consent, but their transmission assets is subject to a separate DCO, which is currently in examination. What the policy says is you should look at the HND and the CSNP, because these are usually a basis for identifying the basis for coordinated transmission. They've already done a lot of work looking at design objectives and minimizing impacts and making sure something's economic and efficient, deliverable and optimized. And so any assessment that a developer wants to bring forward should acknowledge the work that's been done and explicitly draw on it. Now, that's not the end of the matter, because developers should take any opportunities for subsequent local coordination. I don't know if you've got a big cable coming in that's coming from a wind farm away and suddenly there's a solar farm going near it. You might want the solar farm to plug into the same cable. So there's more coordination that can be taken. But the big point is, in designing and looking at designing and siting your transmission assets, look at the work that's already been done. Radial proposals, which are the ones explicitly from wind farms, straight from a wind farm into the shore, should only be considered where a coordinated solution is not feasible. And again, there's a burden on applicants to show that each coordination option has been considered and the assessment that's been undertaken. And it's expected that radial solutions will only cause less harm than coordinated approaches in exceptional circumstances. So the onus is on developers to really show, we've looked at it, we've considered it, but actually it would be more harmful to have a coordinated approach. That might happen, for example, if there's a sensitive site that's in the way of or that's obstructing a coordinated approach. When this lands on the Secretary of State's desk, they will have to, again, this is in the policy, require applicants to explain the steps taken to pursue coordinated approaches. The evidence has to have drawn on the national grid work that's already been done, and the Secretary of State has to be satisfied that options were considered and evaluated appropriately. So it's not a hard cut-off, it's a process point. The Secretary of State will want to check that all of this has been looked at. Moving on to biodiversity and geological conservation, the EN5 contains sections on assessment, mitigation, and decision-making. They're somewhat unhelpfully not put topic by topic, but actually split out into assessment, mitigation, decision-making. So I've tried to put them together in a table. Now, the first one is effectively when you're talking about transmission assets, risks to bird life, both large birds who might fly into something or smaller perching birds who might unfortunately make a circuit between a live wire and a neutral wire. Again, the applicant has to consider if the line will cause any problems along its length, especially having regard to the feeding and hunting grounds of the birds, has to consider mitigation. So can lines be sited away or parallel to well-known flight paths rather than across them, making lines more visible with bird flappers, which I think is the noise that flap the lines and make noise, or fluorescent colours for birds to see, for example. And again, the onus on the Secretary of State is going to be satisfied that all feasible options for mitigation have been considered and evaluated properly. So again, it's a process point. The Secretary of State will be checking that this has all been looked at. Landscape and visual, obviously a huge potential impact for lines, particularly if, then there are going to be overhead lines, and that is the starting presumption. In AONBs and national parks, there is the new Section 85(1)(a) duty to seek to further the purposes of those. That, some of you may be aware, there's been a couple of recent cases on that, New Forest case and CPRE Kent against Secretary of State case came out earlier this year, both judgments of Mr. Justice Mould, both worth visiting on this point, because it's not you can't build anything in the national park, which was the argument run in the CPRE Kent case, but it does mean that you have to actively look at whether the line going through is going to conserve or it's going to further the purposes of the national park. That's seeking to conserve and enhance, for example, the natural environment, look at what can be done, decide whether it's doing any harm, and if not, explain exactly why this needs to come forward. And the policy is clear that the duty to seek to further the purposes, therefore, might impose an obligation beyond just mitigation. It might not be enough just to say, yeah, well, we covered our bits. You might actually have to do a little bit more. Schedule 9 of the Electricity Act, similar in not dissimilar terms. The policy accepts, the EN5 accepts that it might not be possible to fully mitigate adverse impacts. That, I'm afraid, is the nature of building new infrastructure. It says residual impact may, so only may, make proposals unacceptable in the really important landscapes, national parks, Broads and AONBs, but outside that, it's going to be a tricky argument to run. There are requirements to follow things, the Holford rules and the Horlock rules. Now, Holford rules is a set of rules established donkeys years ago, now subsequently reviewed, which is guidelines on overhead routing. They're guidelines on where you put the overhead cables, for example. I won't go through them all because we don't have time. There's 7 of them, but it's things like avoiding altogether, if possible, areas of highest amenity value. That's national parks, AONBs, heritage coast, World Heritage sites. Avoiding smaller areas of high amenity value, if that can be done with deviation without too many angle towers, because the angle towers are the biggest ones. All other things being equal, choosing the most direct line, stuff like that. The Horlock rules are a similar set of rules, but for substations. And the mitigation, again, consider reinforcing existing lines rather than building new ones, considering the most suitable type of support, small towers versus the big ones, trying to rationalize networks rather than just building more wires. And you might say, because the duty to enhance might go further, or for any other reasons, possibly just compulsorily acquiring land in order to provide landscape buffers and landscape mitigation. Secretary of State will consider whether the developments complied with the Holford and Horlock and Holford rules so far as reasonably possible. Again, we'll look at whether all feasible mitigation options have been considered and evaluated and will have special regard to nationally designated landscapes. I want to talk a little bit about undergrounding and subsea cables, because there is a starting, whilst obviously a large number of people along the lines of potential routes will say, well, you should underground near us, you should underground near us. The starting presumption is that overhead lines are the starting point. Now, that is flipped in national parks, the Broads and AONBs, unless it's not feasible to do so. If you're outside national parks and AONBs, the Secretary of State should only grant it, but you want to consider undergrounding for whatever reason. There's a policy limitation on that. And the Secretary of State should only grant consent for underground or subsea cables if satisfied that the benefits clearly outweigh any extra economic, social, or environmental harm, and the mitigation hierarchy has been followed, and any technical obstacles are surmountable. And we'll need the appellant to provide evidence to support that decision. So it's really quite a strict test, and it's not just the local community would prefer not to see pylons or power lines. It's quite a rigid thing. Noise and vibration. All overhead lines can make, all HV transmission lines have the potential to generate noise, referred to sometimes as crackle and hum, and that can be caused and exacerbated by weather conditions and other things like surface grease. So mitigation, things that an applicant has to consider, things like positioning of lines, ensuring the conductor arrangement is appropriately sized, quality assurance through manufacturing, stuff like that. And again, the Secretary of State will want to see that that the assessment has used appropriate methodology. So there's some outlined in the policy itself, one for substation noise, one for overhead line noise. We'll want to ensure that all weather conditions have been looked at, because something like rain can affect the levels of crackle and hum. But again, there's a clear steer in the policy that noise from overhead lines is unlikely of itself to lead to refusal. Need to minimize it, but that's not probably going to be enough to lead to refusal of a scheme. Electric and magnetic fields, all overhead power lines produce EMF, and that can have very direct and indirect effects on human health. That's obviously something that captures the public imagination, and anyone who's dealt with renewable energy projects, I'm sure, will have come across people concerned about EMF. But there are guidelines. There have been guidelines in place since 1998 through an international commission. And in fact, the Secretary of State has published two practice directions, codes of practice, one on demonstrating compliance with those guidelines, one on phasing, because phasing of the power lines can have an effect on EMF. And effectively, the situation is that the Secretary of State wants to be satisfied that the proposal is in accordance with the guidelines and the codes of practice. And if you are, there really is no real particular health and safety risk to anyone. The Secretary of State should, however, refuse consent. There's a clear refusal here if the appellant can't demonstrate compliance with the guidelines and the Electricity Safety, Quality and Continuity Regulations 2022. Now, I think this is realistically unlikely to arise in practice. These are well known, they've been around for a long time. So I suppose for those who are concerned about EMF, having some faith in the codes of practice and the international guidelines that have all been created. And that's what the Secretary of State, as I said, is going to be looking at. Sulfur hexafluoride, this is an insulating gas often used in component parts, but it is a very, very, very potent greenhouse gas. And so the intention of the policy is to try and avoid its use, to try and minimize the possibility of leaks. So as a rule, the policy says avoid the use of SF6. It might be acceptable if there's no proven SF6 alternative that's commercially available, and the cost of demonstrating something bespoke or obtaining something bespoke is grossly disproportionate. And that's again, those are the things the Secretary of State is going to look at, basically. Only granting consent if there's no SF6 or there's no commercially available alternative, and it would be grossly disproportionate in terms of cost to buy something bespoke. And of course, the emissions and monitoring and control measures have to comply with the F-gas regulations, which is a whole other ream of regulations under the auspices of the Environment Agency and the FTT. Reforms then, coming to the end of my talk, three to be aware of. The first is this, which is the recent government reform that ended 2 days ago on electricity network infrastructure, consents and land rights. And effectively, they're proposing to remove 132 kilovolt wooden pole lines from the NSIP regime and increase the NSIP threshold from 2 kilometers to 10 kilometers. The reason being, again, the government acknowledges there needs to be a lot more electrification if we were to move to net zero. But that's the current system's having an unintended effect, as it seems to be catching smaller electricity lines that it was never really intended to catch, that aren't really considered nationally significant. It's led to suboptimal designs as lines are clustering within that 2 kilometer radius to try and avoid the NSIP thresholds. And the government thinks at the moment that 132 kilovolt wooden poles are significantly less environmentally harmful than metal ones. So they were asking about that. We'll see what the outcome is. For my money, that seems like perfectly sensible reforms. EN5, the government's also consulted earlier this year on reforms to EN5. Two big proposed changes. One is endorsing the CSNP to accelerate consenting times. Now, what that effectively means is it would be an endorsement in national policy of the case in the CSNP, which says we need reinforcements for the strategic parameters of the reinforcements, i.e. onshore, offshore, HVDC or HVAC, the spatial envelope. And if a new information comes to light, effectively what that would mean for promoters is they could go to grid and national NESO and say, hey, CSNP did this, here's some new information, can you submit a change control so that there's a slight change? And that would be something for NESO to consider. What it won't do, what endorsement won't do, is endorse specific routes. There won't be indicative routes in the CSNP. It's broad envelopes and that general need for reinforcement. And the reason for that is, as I mentioned earlier, at DCO stage, you can't open up something that's already in a national policy statement. And if the national policy statement says, we endorse this, you won't be able to open up the assumptions, or objectors won't be able to open up the assumptions that underlie that document, the CSNP. It's a similar situation to you see in the water situation. So, for example, the water NPSs say, if a piece of infrastructure is in a water resource management plan, the need will be taken to be established, and therefore a DCO examination won't cover need. Just don't open it up again. Fundamentally, that was part of what was being challenged in the Abingdon Reservoir Challenge that I worked on earlier this year. So that's why that's important, because effectively it establishes the need case and means that DCO can't go back, that the DCO examination process can't go back on that. Second big change is a new set of electricity transmission design principles, which would be a third set of guidelines to consider on top of Holford and Horlock. The reason behind this being that there was a Clean Power Commissioner earlier this year, and he said one of the things that's slowing down this infrastructure delivery is the fact that people can reasonably disagree about what the design requirements require. That can lead to changes, meter process, and it just makes everything slower. So have a clear set of transmission design principles that everyone knows, everyone's clear on, and hopefully that will speed up consenting. Last third of the three consultations to think about is the National Energy Systems Operators CSNP consultation. They've been consulting on the methodologies for the CSNP. The last one took place on 30th of June to the 1st of August. There may be more. And the CSNP is intended to be in place by 2027. So that process is ongoing. And obviously, because of the potential changes to EN5 and what I've set out earlier, that's going to be quite fundamental to the consenting of transmission lines going forward. So that's it from me. Thank you for listening, and I will hand over to Odette.
Thank you, Nick. So I'm going to take over by talking about consenting regimes, but in particular permitted development and Section 37 consents. If I could have the next slide, please. And essentially what I'm going to do is take on what Nick started to talk about, which is the recent consultation on network infrastructure, consents, land access and rights. And the question to start with is, why does anyone care about this? Why is there this big consultation going on? And the big picture is, of course, we'll all be aware of Clean Power 2030, Net Zero 2050. And we're going to have electricity demand doubling by 2050. And what the government said in this recent consultation is that means we need twice as much new transmission network infrastructure by 2030. So in just 5 years, as was delivered in the entire past decade. And similarly, 200 to 460,000 kilometres more distribution network cabling by 2050. So there is going to be a huge amount more of this that needs to get consented, and a lot more people being involved in the process for doing that over the coming years. So the consultation, which Nick started to touch on, closed just earlier this week, and it followed a call for evidence in 2022. And essentially, what this sets out is that people have found widespread dissatisfaction with electricity network consenting and land access processes for networks. And what many people said in response to the call for evidence is that minor infrastructure changes are diverting huge amounts of resources. And there's 5 areas where the consultation proposes reforms. I'm going to touch on the first 2 of these, so permitted development and Section 37 consents, but we're going to touch on some of the other ones later on in the webinar. Before I do so, I just wanted to first take a moment to think about why this matters. I've noticed there's quite a lot of people on this call from local authorities, developers who are not themselves developing network infrastructure. But it is important, for example, if you're doing a project or assessing a project that requires network upgrades along with the main project, for example, a solar farm. And what we have is recent appeal decisions that confirm that where grid upgrade network works are required along with the main proposals, so it might be EV charging stations, something like that, there's a choice whether to include that within the planning application or to leave it for the separate consenting regimes available to statutory undertakers. And especially in Town and Country Planning Act applications, the latter does have some benefits, which is that the final routes or designs of the network upgrades might not be available at the application stage. But it's important, if you are relying on statutory undertakers, separate consenting regimes, to understand what they are, what the time frame of that is going to be, and you may need to explain it to the decision maker who may not be familiar. And an example of where this can cause difficulties is the Thoroton solar appeal. In that case, essentially, the appellant's evidence before the application was determined by the authority indicated that 2 new terminal towers to connect to the 132 kV line were required as part of the application, and some drawings were put in of those towers. Then it got to they weren't on the plans though, and it got to the appeal, and the inspector was a bit confused essentially as to whether these network upgrades were included within the planning application. And so there was a back and forth, there was a delay. The inspector said they hadn't been assessed properly and made the parties go away and do proper landscape assessments of these 132 kV towers. And that was despite the appellant saying, oh, we don't actually need these as part of the planning application. These can be dealt with separately by the statutory undertakers under PD rights and Section 37 regimes. So I think the key lesson for that is you can leave these upgrades separate to the main application, but it has to be very clear what is part of the scheme and what is not for people promoting and assessing what's going on, because it can lead to complications. Another reason it's important to understand these other types of regimes is when you are submitting planning applications or assessing planning applications, recent decisions have shown that if your scheme is ready for Clean Power 2030, so if the extra upgrades required can be done in that time period, that can attract extra weight in the planning balance. And there's some recent appeals I've put on the slides where decision makers have given very recently significant weight to a grid connection offer where the site would connect into an existing substation and contribute to Clean Power 2030 targets. So it's important to understand how quickly those associated grid upgrade works can be carried out. So what are we talking about then in terms of first permitted development rights? So under the GPDO, we've got Schedule 2, Part 15, and that sets out permitted development rights for statutory undertakers and Electricity Act licence holders, including to install or replace substations, essentially, and also install over or underland electric lines. And there are some caveats as to that and conditions on those permitted development rights. We'll get onto the Section 37 in a moment, but where you are required to get a Section 37 consent, the PD right does not pertain. In terms of substations first, though, because this is an area the government is looking to reform, the permitted development rights only extend to substations that would not exceed 29 cubic meters in capacity. And what the consultation sets out is that actually 76% of substations are bigger than these permitted development rights at the moment. And that's causing delays, it's causing costs. So 5 months on average for a planning consent for a substation bigger than that at a cost of more than £20,000. And obviously substations are a critical component of the net zero transition. So we're going to need more, we're going to need bigger ones. And apparently what the consultation said is that to avoid the requirement for planning permission, network operators are installing second substations rather than upgrading theirs. So they've got 2 that are below the 29 threshold. And that's obviously not particularly efficient. It could be not cost effective, and it might even be visually harmful. So briefly then, the proposed changes are essentially to increase that threshold up to 45 cubic meters, where the substations are not more than 3 meters and also not within 5 meters of a dwelling. But there will be a requirement for prior approval in particularly sensitive sites. So that's what's proposed in terms of changes to the permitted development regime under the new consultation. There's also proposing changes to the Section 37 EA Act regime. And just to briefly summarise what that regime is, at the moment, installing or upgrading overhead lines as opposed to underground lines generally requires Section 37 consent from the Secretary of State, and that's regardless of the environmental impacts of the changes. It can be, it doesn't remove the requirement for planning permission, but upon the grant of a Section 37 consent, that can include a deemed planning consent from the Secretary of State. So the focus is on the Section 37 regime for these types of development. There are exceptions to this Section 37 requirement, and I've set out some of the main ones there. So those are for lines that have a nominal voltage of 20 kilovolts or less and are for a single consumer, where the land's in the occupation or control of the person responsible for installation, and other exceptions for minor works set out in the 2009 exemption regulations. So these are things like replacements of existing lines on the same line as the current one. And the consultation sets out a few concerns as to how the regime is currently operating. And one example here is that a change from one of these images to the other would currently require a Section 37 consent. So if you change to a 33 kilovolt line, that requires Section 37 consent because the maximum is 20. And if you change to from a 2-phase to a 3-phase line, that may also require consent, because you've got to comply with the conditions on any previous consent. So essentially quite small infrastructure changes are clogging up the system in a number of ways. Another example here, just from the consultation, is currently where you have an existing line that only serves one customer, it doesn't require Section 37 consent. But if you want it to serve a second user because you've got a second house that's been built, for example, then the original line then requires a consent, even though it didn't require a consent to start with. So all of this is taking up time, taking up consultees' time, and costing money that doesn't really need to be done. This is another diagram from the consultation that sets out essentially the breakdown of Section 37 cases by project type over the last 5 years. And there's a huge growth in these Section 37 applications. So 161 applications in 2023, but 256 in 2024. And much of this growth is driven by the need to upgrade existing infrastructure to accommodate electric vehicles and heat pumps, small renewable energy projects, for example. And there really is a risk of critical delays without reform. So what are the reforms proposed? Essentially introducing a whole load more flexibility as to cases where you do not require Section 37 consent. So upgrading wires from 2 to 3 wires, increasing heights of pole supports, increasing the nominal voltage of existing lines, increasing the nominal voltage threshold to 33 kilovolts for up to 4 consumers, altering conductor types, and permanent diversions of the line. So all of these will soon, if the consultation materials come forward, be new ways that the Section 37 regime is essentially disapplied to save everyone's time. So the key takeaways of all of this, to start with, the consultation is proposing strengthening statutory powers for electricity undertakers to carry out network upgrades. It's important, even if you're not applying yourself for a network upgrade, to understand what powers are available under these separate consenting regimes for statutory undertakers and the timescales and processes for these. It's very important to be clear what network infrastructure upgrades fall within the scheme being assessed and what will be consented separately. And that could relate to underground cables, that could relate to new towers. It's really important to know what is being assessed as part of the main application. And the final point that I touched on at the start, if a development, for example, a solar farm, is Clean Power 2030 ready with a grid offer and the necessary upgrades that can be shown to be in place by that time, that can attract additional weight in the planning balance. So that's the piece on section 37 and permitted development. I'm going to turn over now to Richard to talk about compulsory purchase.
Thanks, Odette. So I'm going to deal with the first of two topics on acquiring the necessary land rights to deliver electricity infrastructure. Obviously, in the case of a development consent order for an NSIP, the compulsory acquisition of land will be included in the DCO. But where a scheme is coming forward for electricity transmission comprising permitted development, planning permissions, and or section 37 consents, there may be a need to promote separate land acquisition processes. And I'm going to deal with the first element of that, the compulsory purchase order, and then Kim is going to address wayleaves. So compulsory purchase orders. I'm just going to set out the scheme and outline first of all, and really the purpose of my talk is just to explain some of the key issues that arise under these CPOs and how those issues might be grappled with in practice. So paragraph 1 of Schedule 3 to the Electricity Act provides for the authorisation of compulsory purchase. It is a right that can be sought by the licence holder, so somebody who holds an electricity licence, which could be a generating licence or a transmission licence. And it includes the ability to acquire rights over land and not just land itself. There's an important restriction which I'm going to return to, which is about the restriction on the purchase of land belonging to another licence holder. And for most licence holders, their standard licence terms will enable them to rely on this compulsory purchase power should they acquire it. So next point, the process itself. As with other compulsory purchase orders, for example, those made by local authorities, the starting point of the process is that the CPO is made by the acquiring authority, by the licence holder in this case. And then there's the process in the Acquisition of Land Act 1981 for confirmation of the order which has been made by the acquiring authority. As with other processes, if there are objections to the CPO, the confirmation process will proceed often by way of an inquiry, but in the absence of agreement, but can proceed by written representations if all the parties agree, or by hearing if that's determined to be the most efficient way to deal with it. And then in the context of the Electricity Act, the inspector's recommendation is then almost invariably considered by ministers and a final decision is made, although there is scope for inspector confirmation of CPOs. So Electricity 1989, Electricity Act 1989 CPOs, and some key issues that arise specific to those CPOs. I think the first one I'd flag is the requirement to be a licence holder at the time of making the CPO. So for some electricity undertakers, or for existing electricity undertakers, that is an easy line to cross. But of course, if you are promoting entirely new infrastructure, you may not be a licence holder at the time that you are formulating your scheme. That may be something which you will achieve at a later date. So there's an important preliminary issue about whether you can show that the undertaking that is concerned here does hold a licence so that it has the power to make a CPO. And that might be something which assists in formulating the way in which you proceed through the licence process with Ofgem. The next key issue to flag is about consultation and negotiation with landowners. I'll say a bit more about that in a moment. But I think a key point here is that particularly when we're looking at transmission infrastructure, those negotiations may be extensive because by its nature, transmission infrastructure is likely to cross multiple land interests and intersect with various other important interests, for example, land of statutory undertakers. I think the other thing that is important, I'll say a bit more about this too, is the length of time that CPOs take, because there's the formal process of making the CPO, of advertising it, of receiving objections, submitting for confirmation, preparing for an inquiry and waiting for a determination. And in practice, that can be a process which is certainly measured in months and in practice measured in more than a year. There's then the interaction with other license holders, which I've touched on and I'll come back to, and with other statutory undertakers. Obviously, there are protections for statutory undertakers, land more generally, beyond the protection in the Electricity Act for other license holders. The other issue which I think is important for these schemes is the uncertainty that may arise where the land requirements are critical to funding decisions. So obviously, if compulsory purchase is required, it may be that that needs to be promoted at a stage where the final funding decision of the scheme has not yet been made, because it's not yet known whether the land is going to be available. And this then has a circular effect, because the absence of a final funding decision may reduce the prospects of being granted a CPO. And then finally, managing the inquiry risks, as I put it. So that's the sort of litigation risks relating to CPOs. So I flip now to try and address some of those issues from my experience in recent years with Electricity Act CPOs specifically. As I said, these schemes may involve multiple land interests and various different rights being required. So, for example, schemes will often require ongoing rights over land or under land, for example, for placing cables in the ground. But they may, during construction stage, require much more extensive rights in terms of location of construction compounds, construction rights to deliver the scheme. This involves necessarily formulating a clear package of land and rights that are required, and then negotiating on that package with individual landowners. One of the difficulties that seems to regularly arise is that many of these schemes in practice are promoted around hotspots, which is a point that Nick has touched on as well, where there's competition for land interests, because good points of connection will be good points of connection for transmission schemes. They may also be good points of connection for generating schemes. And we see increasingly a clustering of activity around those particular hotspots where the wider grid can accommodate the introduction of new generating and transmission assets. There is, of course, in any compulsory purchase order, a need to show a genuine attempt to acquire land by agreement. And that can be difficult in practice where the scheme funding is contingent on land rights being in place. And what I mean by that is that in many cases, it is not open to the promoter of the CPO to simply go and buy land interests outright at an early stage, because they don't yet have funding for the scheme in question. And the final point, I think, on engagement is just noting the problems that may arise in terms of the flexibility to accommodate landowner requests at early design stages. It's a perennial frustration in these schemes that obviously there's a preliminary set of designs that will be informing land rights, but at that point, there's often a limit to the extent to which there can be engagement on reducing the land take, altering the rights packages to accommodate specific landowner needs. And that means landowners are faced with generic responses to requests rather than necessarily engagement about their specific needs and how the scheme can sit alongside those. And that's particularly evident in the case of linear schemes where, for example, different agricultural practices may require different accommodations to be made. Timescale. I think there's just a broad point here, which is that the 2030 target, the need for grid decarbonisation, and the need for the transmission and distribution networks to respond rapidly to those changing generating and use requirements means that delivering CPOs can be challenging within those timescales. I think that can be helped by engaging early on land issues, making sure that those issues are integrated into scheme definition and design. So there's a clear idea as to what land is required for any element of the scheme. And I think also engineering input into land negotiations. The most successful CPOs, in my experience, are ones where there is the ability to flex to particular landowner requirements and say, well, we can accommodate you in this way, but you can only do that if you have good engineering input to say how the scheme design can be modified without creating an impediment to delivery. And then I think the other aspect on timescales is early engagement with the department and with the planning inspectorate to ensure that your CPO is going to be dealt with promptly once it's submitted for confirmation. Other license holders. So this is the tricky problem that's provided for in the Electricity Act, which is the restriction on acquiring the land of another electricity license holder. Obviously, engagement is the starting point, and specifically understanding the use of the land which is going to be affected, understanding how that license holder does and intends to use that land in the future. And the bottom line is that the consent will not be forthcoming if the other undertaking is put at risk of not fulfilling its functions and can show that its own license obligations would be put at risk. These are really, in practice, tend to be about the detailed management of interfaces, and therefore it's technical engagement rather than legal engagement, which is likely to lead to the best outcome. Funding and uncertainty. This is a particular problem for schemes which are contingent on future government funding. The threshold for confirmation of a CPO, as you'll know, is a reasonable prospect of funding, not certainty as to funding. But it's important nonetheless to understand the timescales for funding decisions and the commercial delivery model proposed, so that there's a clear impression for the Secretary of State in due course as to what is the route to a financial close on the project, such that it can be said that there's a reasonable prospect. And where that is contingent on some element of government funding, particularly in novel areas such as carbon capture, it's important to fully explain the process that government will follow and when it is expected that those final funding decisions will be made, so that there is some clarity around any impediment to the deliverability of the scheme for funding reasons. Then turning to inquiry risks. So this is not just sitting in the inquiry, but also the preparation for it and the time after it. I think that the first piece of advice I'd give is this, and that is to keep in mind the high threshold for confirmation of a CPO. And that's something to be kept in mind, whichever side of the fence you're on. It is necessary to show a compelling case in the public interest. Although it's a high threshold, it's worth remembering, though, that when we're looking at these Electricity Act schemes, particularly in the context of low carbon or zero carbon energy and transmission, the CPO scheme is likely to interact with government policy on net zero, Clean Power 2030, and reflect those things which have been identified in the national policy statements as being critical national priorities, perhaps enabling CNP schemes to come forward, for instance. So what's really required is a narrative that plugs the particular CPO proposal into that wider government policy, which establishes or is capable of establishing a compelling case. Another aspect that is important in preparation is consideration of alternatives. This is a common issue for CPO inquiries across the board, including under the Electricity Act. And it's necessary, in my view, to have a really clear articulation as to how those alternatives have been considered, why they do not meet scheme objectives. So that may involve revisiting previous decisions that have been made during project evolution. It may involve considering alternatives that are put forward by third parties. And it's important to articulate what the real objection to it is. That can include cost differences. It's not the case that you have to promote the alternative which is most costly to the promoter to avoid any land acquisition. It may include environmental effects, a different effect of a particular proposal, and it may include wider deliverability issues, for example, engineering challenges or the need for additional consents. So that's an area which requires particular ongoing consideration. And then I think I've already touched on negotiation, but it's important when you get to inquiry stage to be able to evidence a clear and consistent negotiation effort over the months and years running up to that inquiry, where you can say to an inspector, we've done our best to reach agreement and we simply haven't got there. I think the final point on inquiry risks is trying to resolve any planning impediments in advance. So that means seeking to obtain the planning permissions that are required for the scheme, showing the route to consent. So, for example, if you're relying on a mix of planning permissions, permitted development rights, Section 37 consent, which some of these complex CPO schemes will do, you need to be able to have a clear explanation as to how each element of the scheme is consented or will be consented. So then a sort of reflection as to where we're heading with this, I think there is potential for a significant increase in the scope of electricity at CPOs. And that is reflective of the matters that Nick and Odette have already addressed, increasing permitted development thresholds, lowering DCO thresholds, or increasing them, perhaps changing the thresholds for the DCO so that they apply only to the largest of schemes, raising the prospect, therefore, of local consenting and permitted development for really quite substantial schemes where land rights are likely to be required. And I think then it becomes possible that the planning and compulsory purchase order route may, in some schemes, deliver faster outcomes than a DCO could in any event. And therefore, the possibility of using those routes needs to be explored at an early stage in scheme design so that the consenting route, which is going to be best for that scheme, can be identified. And I think those points really require early consideration of all the possible routes to obtaining the necessary consent and assembling the scheme. I think there's a word of warning, though, which is that linear schemes in particular, where multiple affected landowners are engaged, can be protracted through the CPO process, whereas under the DCO process, it may be easier to sort of group together those objections into a more focused process. So there is a risk that needs to be thought about in deciding whether to pursue the sort of CPO and local consenting route. So with that, I'm going to hand over to Kim to deal with the last topic on wayleaves.
Thank you, Richard. And yes, as Richard said, I'm going to be looking at the topic of wayleaves for electric lines, sort of managing disputes, but really primarily focusing on the reform proposals in the government consultation that Odette touched upon earlier. So before getting into that, I suppose the first question for anyone not familiar with this topic is what is a wayleave? What are we talking about here? And simply put, it's a right of way over private land. For the property lawyers in the room, that will be raising the question of, is it an easement? It's similar to an easement, but obviously an easement requires a dominant tenement, so i.e. a piece of land that is going to benefit from the right of way. That's not going to be the case here because it's an organisation, i.e. the electricity licence holder is going to benefit from the wayleave, and they don't necessarily own neighbouring land, and they shouldn't need to in order to get one of these rights. So it's its own form of right of way. Some of you may have come across these in other contexts as well. So, for example, in relation to telecoms infrastructure. And so for the purposes of this webinar, I'm focusing on wayleaves specifically for electricity lines and under the Electricity Act, which Richard has just been talking about. And I should also note just at the outset, as I'm sure is quite clear, this is separate from the planning consent process. So once you've got your planning consent or your DCO or whatever is required, you might then need to get these kinds of rights over private land. So in terms of the consultation, sorry, I'm just struggling to get the next slide. Thank you. So it's the same consultation that Odette was touching on in terms of electricity network infrastructure, consents, land access and rights, which closed just earlier this week. And just a quick reminder of the overarching purpose of that consultation, which is looking at changes to land access rights and consents processes for electricity network infrastructures in order to support the transition to net zero and secure clean power by 2030. I'm going to be focusing on those sections that concern necessary way leaves. And I suppose it's obviously important to the transition to net zero and clean power by 2030, because once that power has been generated, it needs to get to the end user somehow, and that will require crossing often bits of private land. So in terms of the current position in relation to way leaves, if you want to run an electricity line from, e.g., for example, a solar farm to a town or a village, then the chances are you're going to need to go across some private land, and to do that you need permission from the landowner or occupier. And similarly, if your cables are already running over private land, you'll need permission to retain them there or to get onto the land to maintain them. And if once that original permission has expired, you'll need to renew it. Or if that permission was personal to the current occupier or owner, then if the land changes ownership, you'll need to renew it. So that permission can, of course, be secured through negotiation with the landowner or occupier. But failing that, then there are these compulsory purchase procedures provided for under the Electricity Act 1989, which are known as necessary way leaves. And a significant benefit of the necessary way leave granted under the Act is that it will bind any person who is at any time the owner or occupier of the land, i.e. it will run with the land, and that's under paragraph 6.6 of Schedule 4, which I'll come on to in a bit more detail in a moment. So that will operate more like an easement than if you've got a negotiated agreement, which will usually result in a license that's agreed between the license holder and the owner occupier of the land, and that's usually would be personal between those parties, and will cease to be effective if the land changes hands. So I'm going to be focusing on these necessary way leaves under the Electricity Act, and applications for those are determined by an inspector appointed by the Secretary of State for Energy, Security and Net Zero. The process for that application in outline is, first of all, to try to agree something through voluntary negotiation, but if that fails, then that will involve the negotiation of a contractual arrangement between the license holder and the landowner or the occupier. And if that can't be reached, either because it's not possible or practicable, then the license holder can apply for a necessary way leave. That would be in the context of a new cable or a new piece of infrastructure. If you've got existing infrastructure, then the license holder is obligated to remove the existing lines from the land after 3 months of being given notice to do so by the owner or occupier, and therefore would need to make an application for a necessary way leave within that period to avoid that from happening. Step 2 then is of these notices. So in the case of new infrastructure, the notice would involve the license holder giving notice to the owner occupier, requiring them to give a way leave. In the case of existing infrastructure, you would have the owner occupier serving a notice to remove on the license holder, which is a formal request for the removal of lines and associated equipment from their land. So once you've had those notices, then an application for a necessary way leave can be made. In the case of new infrastructure, if the owner has failed to give a way leave within the period specified in the notice, or gives a way leave but subject to conditions which the license holder objects to, then the license holder can make an application. And similarly, in the case of existing infrastructure, then that application needs to be made within 3 months of a notice to remove being served. Once the application's been submitted, it can then be placed in abeyance. It's called put on hold at the request of either party to enable more time for negotiation. But if either party does not agree to that, then it will go on to the next stage, which is the hearing process. Now, the hearing process can be either by written representation or an oral hearing before an inspector appointed by the Secretary of State. And those are actually planning inspectors. They'll conclude a site visit and review the evidence and then submit a recommendation to the Secretary of State. Importantly, for what we'll come on to, each party bear their own costs of that hearing process, although the reality is that a lot of those costs tend to fall on the licence holder, who's got to sort of evidence and justify the application. After that, there'll be the Secretary of State's decision, which is usually done as soon as possible, which is published as soon as possible after receipt of the inspector's report. And the way leaves granted in England and Wales are generally granted for 15 years, which is in contrast with Scotland, where they're normally granted for 40 years. But it will vary on a case-by-case basis, and come on to that again in relation to some of the reforms later on. And I should note at this stage that compensation for the grant of away leave is dealt with separately by agreement or by the upper tribunal, but that will not be determined as a part of this process. So the statutory framework, just a very quick overview there, or just a slide to reference if and when you're dealing with one of these. But obviously the starting point here, you've got Section 10, which grants the powers to electricity licence holders set out in Schedules 3 and 4. Schedule 3 is some of the compulsory powers that Richard has dealt with, and then compulsory purchase powers. Schedule 4 is these necessary way leaves that I'm focusing on. Paragraph 6 in particular is the critical part, which is where it's necessary or expedient to obtain the right to install and keep installed an electricity line on, under or over any land, or to keep an electric line installed on, over or under any land. And that is the necessary way leave. And this is where it says the Secretary of State may grant the application to the licence holder, grant the leave subject to such terms and conditions as he thinks fit. And that prior to doing so, the occupier will be granted an opportunity to be heard by a person appointed by the Secretary of State. So that is the hearing process. Paragraph 7, as I say, deals with compensation separately from the hearing process for the grant of a way leave. And I should also have included on that slide paragraph 8, which deals more specifically with issues arising with existing way leaves and the continuation of those, and how you kind of get into this process in relation to those. There are the procedure rules dealing with the hearings for if and when you are dealing with one of these are the electricity, necessary way leaves and felling and lopping of trees hearing procedures, England and Wales Rules 2013. Lots of detail in there about how the process works. But supplementary to that, and quite potentially a more user-friendly guide, is the government guidance, which I've put the link to there, which includes 2 very handy flowcharts, which I couldn't get into a format that was legible on the slides really, but do go and have a look at that if you need a sort of introduction into how this process works. They are quite usable, at least for now, unless and until things are reformed, as I'm coming on to in due course. And then just very briefly, the purpose and the scope of a hearing under the current law, what is basically looking at why is it necessary or expedient for the electricity line to cross the particular land in question. So that's necessarily going to be considering whether there are any alternatives, and if so, are they practical? What are the cost implications of those alternatives? If it's an existing line, why does it need to be retained? It's normally going to be quite a lot harder to object to an existing line. And what are the effects of the electricity line on the use and enjoyment of the land in question? Generally, these hearings are going to be very fact-specific to the particular situation at hand, but these are the questions that you're going to need to be addressing in your evidence on either side. So that's a very brief overview of the current law. What are the problems with that, at least as identified by the government's consultation following the call for evidence? Well, number one is that the process is too slow. These applications can take up to 24 months, and that's in addition to the voluntary negotiation stage at the beginning. The Secretary of State received 412 such applications in 2024, and it's predicted to rise for a lot of the reasons that Richard gave. You know, that we're driving towards more and more clean energy, and that requires more and more infrastructure to get the electricity where it needs to go. And so these are going to continue to increase. The second big problem is the perception that these applications are quite unbalanced. The landowner can serve a notice to remove at no cost, and that triggers the statutory process and the requirement for the license holder to make an application, but the landowner is then not required to engage any further in that process. And because each party bears their own costs, as I said, you then end up with this position where the license holder is having to provide evidence and participate in a hearing or a written reps procedure and at their own cost, without the other party having to really engage in it. And they're having to present the case for retaining the equipment. The third problem that arose from the call for evidence was the time and resource that's spent by the department in reviewing these applications, which actually a lot of which are not within their gift to determine. So this is the point that I was saying about compensation not being a part of the paragraph 6 necessary way leaves application process. But notwithstanding it not being a part of it, you have to go through that paragraph 6 application process to get into the then upper tribunal process for compensation. And that's because of the wording of Schedule 4, paragraph 7, which says that where a way leave is granted under paragraph 6, the owner-occupier may recover compensation, and that will be determined either by agreement or by the tribunal. So you have to go and get a decision of the Secretary of State under paragraph 6 to then trigger the compensation determination provisions under paragraph 7, which means that in a lot of these cases, actually, there's no dispute over the principle of the line running over a piece of land, but the question is about how much should be paid. And the department has to review these and determine these applications, even though that's the case. And it's not always necessarily clear that that's the case from the outset. So those are the big problems identified. What has been proposed to address that? Well, proposal number 1 is the introduction of a requirement for the notice to remove to include a reason for removal, and then an extension of time for the license holder to make an application following receipt of that notice. So as I said, the notice to remove is served where there's existing infrastructure. The license holder then has 3 months from the date of the notice to apply under the Act, and if they fail to do so, they have to comply with the notice and remove the electricity line from their land. That notice doesn't currently have to give any reason as to why they want the line removed, and specifically they don't have to say whether there's an objection in principle or whether it's just a question of compensation. So the proposal is to remedy that by requiring the notice to indicate, first of all, whether there's an issue in principle or it's about compensation. And if there is an issue in principle, to specify one or more of some specific grounds that will be set out by the government, those grounds being impact on use and enjoyment of the land, intention to demolish and reconstruct the property or carry out substantial works of reconstruction, i.e. redevelopment, breaches of any existing way leave agreement, impacts on the commercial use of the land, risks to health and safety of owners, occupiers, users of the land. And so you'd have to choose from that list. And alongside this, giving the license holder more time, so up to 6 months, to make an application after receipt of that notice. And so the idea of that really being to facilitate more informed negotiations and to encourage voluntary agreement without the need for an application, but also to enable those applications to be dealt with more efficiently. I'm just going to run through the next ones quite quickly because I'm conscious of the time. The second proposal is to remove the requirement to obtain consent of both parties for the written reps procedure to apply. At the moment, that's a requirement. The idea being the default would be a written reps procedure unless one of the parties requests otherwise. Again, just to speed things up and to take and to reduce the cost of dealing with these applications to the parties. Then the third one is quite an interesting one. One that I kind of query the benefits of. I mean, they're saying they're going to remove the requirement to appoint an external inspector and have officials within the department deal with these matters instead. And that's largely because of the pressure on PINS inspectors and them being pulled and asked to prioritise other more, other decisions. But that's leading to an average of 7 months for inspectors to determine these applications, despite only really needing 2 to 6 days to actually spend on it. It's just that they've got their capacity is very limited. Or just query whether officials in the department actually have more time. I don't know, but that's a question mark there. Then supporting the use of virtual hearings where the inspector considers this to be appropriate. That seems sensible. It's obviously something that we did in the pandemic for a lot of different contexts and can be cost saving for all parties. And then the final proposal is to increase the standard duration of a necessary wage leave from 15 to 40 years. Just to note that at the moment there's a discretion on the Secretary of State based on the circumstances of a case to grant it for any period that they see fit. That discretion, they're not proposing to remove it, but the guidance currently is that where there's no good reason otherwise, it will be granted for 15 years, and that seems to be the practice. So the guidance is going to be updated to make the starting point 40 years. And that's more in line with the lifespan of the asset usually, and saves having to make multiple such applications during the life of the asset and the uncertainty that arises from that. So thank you very much. That was a very quick run through those. What next? Well, the consultation is now closed, as Odette says. And so the government is reviewing the feedback, and then they will be looking to deliver these proposals over the next 18 months. So watch this space and see what they decide to do. Thank you very much. I'll hand back over to Richard for the Q&A.
Thank you very much, Kim, and thank you to Nick and Odette as well for their excellent presentations. So we'll pick up some of the questions that we've received in the remaining few minutes until we finish at 11:30. I think that the first question that we received was about whether undergrounding is something that should become more into focus, given the fact that it doesn't require a development consent order. I mean, certainly from my perspective, I think undergrounding schemes can have all, if not more, of the complexity of overhead lines. And I'm not sure that the fact that there's a different consenting regime is necessarily means that the scheme is more attractive in those terms. And certainly in the schemes I've been involved in involving underground cables, there is still a lengthy consideration of impacts on landowners, construction impacts in particular can be prolonged, various technical issues on difficult crossing points and so on. So I think in terms of the different consenting regime, it may not prove to be a decisive factor. I think the next set of questions about the national policy statements and about future change to the NSIP process. I don't know, Nick, whether you want to come in on timescales for that and likely outcomes.
Yeah, absolutely. Just picking up on the undergrounding point, it's a point that's also made in EN5, which says that undergrounding can have, in fact, worse environmental impacts than the overhead lines. And you've got the additional technical issues, Richard, that you talked about, which is, what happens if something goes wrong with somewhere in the line? If it's all entirely underground, then you've got to get in, dig it all up and try and find it. So I agree with your point on that. In terms of the NPS questions, first question was whether we have any idea when the revised NPSs are expected. I don't, I'm afraid. I don't think they've even been through the parliamentary process yet. There's been consultation and the government is probably revising or reconsidering the drafts based on that consultation. Then we have a parliamentary process. So not immediately, if I can put it in those terms. The second question then was whether there's advice for those intending to respond to the consultation on streamlining the NSIP processes. Difficult to say in the abstract because it really depends on what point of view you're coming at it from, local authority, promoter, landowner. I think I wouldn't spend time trying to re-argue points about whether we do need to speed up infrastructure consenting, because the government's been clear on its policy approach. So focusing on the questions. And then it sounds trite, but bear in mind that, you know, the government can receive anywhere from 150 to 10,000 consultation responses, so which it all has to review, or some poor civil servant has to review. So write clearly, because you want your points, just like advocacy, really, you want your points to get across. So you want them to be sort of short and sharp topic sentences for your answers. Then if you've got evidence to back it up, put that in the body of your paragraph. And if you've got a new point, put in a new paragraph. I hope that's helpful. It's not meant to sound patronizing, I'm sure it might. But having looked through a number of consultation responses on, you know, when we do DCOs and whatnot, it's amazing how often the content gets lost because it's not been written down clearly. And actually, if you've got good points to make, then making it really clear and easy for whoever's reading it to pick up your points out of the 10,000 others that might be made is much more likely to get it across than a stream of consciousness bit that might have 3 or 4 interesting points in it. But if it's not easily written and, you know, split in paragraphs or using things like first, second, third, and with evidence attached to it, then however good the point is, it might just get lost in the sea of all the other points. So that's kind of the biggest bit of advice I can give.
I think just on the sort of what the changes that are coming forward and consultations and so on, it's worth, you mentioned, Nick, the CSNP, the Centralised Strategic Network Plan, and the importance that's given to that and will be given to that in the emerging NPS. And of course, there's a process there of strategic environmental assessment. There's going to be a consultation on that. So there's going to be sort of a separate stream of thinking going on about, fact, we need the network to give effect to the wider strategic spatial energy plan. So there's a sort of questions of substance, of location of assets and so on, is also going to come up in that consultation process. And it may be that when we get speeding up of NSIP processes in this context, that in fact a lot of the shape of the network has already been decided by those planning processes.
Yeah, I think that's fair. So absolutely engage with the CSNP as well whenever the chances arise.
Thank you. Odette, do you want to pick up the question about assessing the grid connection for a generating scheme?
Yes, that's a good question, and one I should have really touched on earlier. So this goes back to the question of if you have to include the network upgrades as part of your main application, for example, for a solar farm or EV charging station. And there's inspector's decisions saying basically you don't, you can rely on the separate regimes available to statutory undertakers to do that consenting separately. An important caveat to that is that if your scheme is environmental impact assessment development, so if you're within the EIA regime, then there's a requirement as part of your environmental statement to assess the project, and the project may not be coterminous with the red line boundary of your application. So even if you are saying we're not quite sure exactly what network upgrades are required, they're going to be dealt with in future by the statutory undertaker and consented separately. It may be that as part of the EIA, those future upgrades are still part of the project. And it's hard to say in a particular case whether that would be the case or not, but there's been quite a lot of recent case law on this. So the Ashchurch case in the Court of Appeal and the Together Against Sizewell C case in the Court of Appeal, which set out the relevant considerations for when 2 separate applications effectively form the same project for EIA purposes. So I'd have a look at those 2 cases and how the factors set out by the Court of Appeal would apply to the facts of the particular case. And the one other point I just want to flag is that also for NSIPs, EN3 says at 4.11.7 a preference for including network infrastructure upgrades together with your main renewable energy development. So if you're in the NSIP regime, you might have to justify why you're leaving it till a later date. It's a bit different under Town and Country Planning Act. Thank you, Richard.
Thank you. And worth remembering, I think, on that obviously this question of the impact of transmission assets might arise for energy users as well. So data centers, for instance, where new grid connections are being provided, the same sort of issues might arise as new generators. Kim, do you want to pick up any of the Wayleave points? I know we're running short of time, but I think there were a few questions there.
Yeah, I can just jump in very quickly on those. I think the first one was about whether necessary wayleaves are registered on Land Registry, and the short answer to that is no. If you look at Schedule 4, Para 6, 6A, a necessary wayleave granted under this paragraph shall not be subject to the provisions of any enactment requiring the registration of interests, etc., affecting land. The second question within that was whether you'd need to prove that apparatus was lawfully placed in relation to an if you're seeking a wayleave for existing apparatus. And I suppose that would come into the question of whether it's necessary and expedient to grant the wayleave. So you probably would, you would want to be looking at the consent to put the apparatus there as part of your evidence. And the third question of what happens at the end of the term if no notice to remove is served. I mean, as far as I read it, there is no time limit under paragraph 8 to serve a notice to remove. So it's not a case of an implied wayleave appearing that the owner can serve their notice to remove at any time. Obviously, that might be a factor. A delay might be a factor in terms of then showing that there's significant impacts on the land when it comes to the hearing or any objections, but that would be that. It would come in that way. I think I'll probably leave it there given the time.
Great, thank you. I'll just very briefly say something about a couple of the questions that touched on my talk. So first of all, about license holders and who is a license holder. So the Electricity Act CPA provisions would apply to both those who have transmission licenses and those who have generating licenses. So if you can show that you have the license granted under the Electricity Act and that license does not preclude you exercising the CPA powers in its terms, then that's potentially open to you regardless of how that license has come about. I think another question was about interference with other statutory undertakers. I think there's a distinction here. There are the specific protections that are put in place in the Electricity Act for other license holders, and that's the requirement for Ofgem consent. And that is obviously a specific requirement that applies to Electricity Act CPOs where you're trying to acquire land or rights of land of another license holder. That's a further requirement to what we see normally in CPO for the protection of statutory undertakers, which is obviously the normal principles around identifying that the land is not required for their undertaking. And if there's a dispute about that, the possibility of following the certification process. So potentially 2 steps to go through if you're interfering with a statutory undertaker who has an Electricity Act licence affecting the land in question. I think we'll leave it there. I'm sorry for not answering all of the questions. Thank you very much for joining us and for asking lots of interesting questions. And we hope to see you again soon. We will distribute details of the next session on this topic as soon as possible. And thank you again.